Good afternoon, everyone. My name is Claire Vergara, and I'm a member of Plunkett Cooney's Medical Liability Practice Group. It's my pleasure to serve as coordinator for today's program, which will focus on what to do and not to do should a state investigator come knocking at your door to review a complaint against your practice. Unfortunately, we see this all the time with our clients. They mean well and are trying to be helpful, hoping that the investigator will ask a few questions, then be on their way, satisfied that the allegations in the complaint are unfounded. That couldn't be further from the way things typically work. But before we get in depth into our discussion, I would like to mention that joining me today on our panel are the co-leaders of Plunkett Cooney's Medical Liability Practice Group, Justin Hakala and Eric Raymar. I will provide more formal introductions in a moment. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 130 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's Medical Liability Practice Group includes attorneys, nurse consultants, and paralegals across Michigan who work exclusively to defend medical malpractice claims and to represent clients targeted in licensure actions. Now, a bit more background about today's presenters. Justin Hakala is a partner in Plunkett Cooney's Bloomfield Hills office. He has represented doctors and other healthcare professionals directly and through their professional liability insurance providers for 15 years now. His practice also includes what I would describe as an alarming increase in the number of state licensure investigations, which of course is our focus today. For over a decade now, Eric Raymar has exclusively defended physicians and other healthcare professionals in medical liability claims. A partner in our Detroit office, Eric serves as co-leader of Plunkett Cooney's Medical Liability Practice Group. He also maintains a robust practice involving nursing home and extended care facility litigation defense and licensure actions brought by the state against healthcare professionals. As for myself, my name again is Claire Vergara, and I am also a member of our Detroit office. I have the privilege of representing doctors, nurses, and other healthcare professionals in licensure actions and in the defense of medical liability claims. Like Justin and Eric, my practice involves such claims as birth trauma, spinal cord injuries, alleged misdiagnoses, and others. I also serve as defense panel counsel to numerous professional liability insurance providers in Michigan. Now for a few housekeeping notes about today's program. For the Q&A portion of our webinar, we will use the questions window on your GoToWebinar navigation display. Please take a moment now to locate the widget and feel free to enter questions as they occur to you during the program. Finally, I want to mention that today's session is being recorded, and that recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share a link or direct your colleagues to that page. Thanks again for attending today's webinar. Now let's get started. As a brief introduction, the system of licensing medical practitioners was generally designed to protect the public from doctors who are inadequately trained, incompetent, or whose conduct is illegal or abusive towards patients. Medical practice laws all over the states mandate that medical boards have the legal obligation to take disciplinary action against licensees who have known to injure or endanger or behave inappropriately or illegally towards patients. For Michigan investigations, it's particularly interesting. Michigan ranks number 13 in the whole United States, having approximately 35,000 physicians. And a surprising statistic that Michigan has the highest rate in the country of disciplinary actions, about 1.74 per 1,000 doctors each year. And it's important to address timing. Investigation to the complaint time typically lasts 90 days. within that 90-day period, the department has to issue a formal complaint or dismiss the complaint. There's a 30-day extension window, making it 120 days on certain occasions. Additionally, from investigation to the committee rendering a decision about potential misconduct, a decision has to be made within 1 year per statute. And some interesting statistics, the Bureau of Professional Licensing issues a report every single year. And as of March 2023 for 2022, there were about 5,000 complaints issued against physicians. About a quarter of them were actually investigated, and 900 of those ended up being complaints. And in total, I have some statistics here about what the board issued by way of disciplinary orders, and you'll see that about 87% of them issued a fine, and the other percentages were reprimands, probation, suspension, or revocations of professional licensing. And some other interesting facts for you. Of those final orders, 23% of them were contributed to negligence, 19% to incompetence, 11% to good moral or lack of good moral character, and the rest for other misconduct and violations. Okay, now we'll turn it over to Justin.
Thanks, Claire. My name is Justin Hackle. I'm the co-chair of the Medical Litigation Department at Plunkett Cooney. As Claire mentioned, a big part of my practice, and unfortunately a growing part of my practice, is the defense of the licensure investigations for physicians and other professionals. That includes mid-level providers, nurses, NPs, PAs, but also other health professions. Some, for better or worse, some of the professions seem to be more commonly featured in medical investigations. Typically, therapists, counselors, mental health professionals, I think, come up more frequently than other professions, but we see cases with chiropractors and podiatrists and others. They're all subject to the same process, although the boards vary. And I've got it outlined here for us. It starts, I have complaints at the top. That's kind of a misnomer. A complaint from a patient or a member of the public is one way to start these types of investigations, but they also can come up due to settlements, verdicts, and sources like that. We're going to talk about the informal interview, which is the kind of the first best step to address investigations from the licensee's perspective. I say that because it is before a complaint is issued. There's no formal discipline that has started or process in place, and you're still dealing with the investigation phase. It is probably the best time to address these and nip them in the bud, so to speak, but it's also the most dangerous. And it's dangerous because of the way it's framed by the state. They call them informal interviews. It's usually precipitated by a letter and or a phone call to the licensee. They don't always convey the importance of what's happening, and they don't give this outline of the process. Hey, if this doesn't go your way and I don't like what I hear in the informal interview, we're going to be talking about whether or not you're going to be licensed and be able to support yourself and your family at the end of this process. So practitioners, licensees don't always appreciate how significant this process is when they get those initial contacts. If we go into the next slide, this follows through the process. It starts with this investigation, but if a formal complaint is issued, there's a whole process that follows it. It all circles back to the board. The board, although you do have the right to a hearing in front of an ALJ, the board decides whether to accept that decision, imposes discipline if there's a settlement or a decision by the ALJ, and ultimately ultimately makes the decision subject only to appeal, which is heard by the Court of Appeals in Michigan. We're going to focus on an informal interview today. So the informal interview is not informal. It is usually with an investigator rather than an assistant attorney general. And it's different than a compliance conference. A compliance conference happens after a complaint is issued, and it's with an assistant attorney general and what they call a conferee, which is somebody of the same profession. By contrast, at the investigation stage, your investigator is not a professional. If it involves an anesthesiologist or a chiropractor or somebody else, the investigator won't have an anesthesiology background. And on medical cases, they usually won't have that background or the ability to kind of dig into the details. So you have a slightly different audience. It's not a peer-to-peer conversation. But the investigator is a person, and that is, it's kind of a silly statement, but it bears remembering, because we like to think that you go into these interviews with an objective individual who's just there to gather the facts, but that is, in my experience, almost never true, because that's not how humans deal with things. The investigator has read a complaint, probably reviewed any applicable records, medical records, or whatever type of records are at issue, and they will have an agenda. And when I say an agenda, I don't mean they're out to get anybody. It's not necessarily negative, but they have a preconceived notion in mind. They may be there to try to get whatever information they need to close the file. They may be there because something rubbed them the wrong way, and they're going to see if they can get a concession out of the licensee that will help, because they're building a file. And that file is going to be turned over to the Assistant Attorney General with perhaps a recommendation or however it's written up. And although they will tell you up and down, I don't make the decisions, the reality is how they write it up will affect whether or not a complaint is issued. And what they want is to have their decision, their recommendations be justified. They don't want to have to answer to an assistant attorney general who comes back and said, hey, why did you recommend a complaint in that? We just had the compliance conference and this is stupid. This doesn't make any sense. So they want to make sure their file is covered, their butt is covered, so to speak. And that becomes important because it affects strategy. As I mentioned, they usually don't have deep knowledge. They sometimes get internal reviews from experts. When I say internal, I mean the state will actually retain an expert in the field and a report will be issued. The interviews themselves are not usually long, and the strategy for how to deal with these varies widely. You may be in a situation where the person screwed up and they're caught, and now you've got to figure out how to most gracefully fall on the sword and mitigate your problems. It may be the other end of the spectrum where what was done was in keeping with the standard of care, and the name of the game is convincing the investigator that the medicine at issue was appropriate. And you get all ranges of those. It's dictated by the facts. I want to give an example of where this can go sideways. And John, if you can give us the next slide. I'll give you the example in just a second. As I said, there are two important things about informal investigations. First, it's the best opportunity to give the state the information it needs so they come to the conclusion that you want them to come to, but it is also dangerous. And this example will illustrate that. I recently represented a chiropractor who was acting as a sideline physician for high school football games. The photo we've got here is looks to me like this is baseline concussion testing. One of the things they do to check for concussions is to follow eye movement horizontally. And I think that's what's going on here. And that's what I think of a sideline physician at a football game doing 99% of the time. But the case I handled wasn't like that. Instead, the chiropractor was doing concussion screening and making sure people didn't need emergency attention and things like that. But he was also doing chiropractic adjustments for patients, children, kids, on the sidelines. When he went into the interview, and take us to the next slide if you would, John. When he went into this interview, he was not told, hey, doctor, anything you say or do today can and it will be used against you. He wasn't told he had the right to an attorney. He wasn't Mirandized. He didn't get any of that information. And that's important because he did what many of us would do in this circumstance. And for those of us who represented defendants who've been sued, for those of us who've handled grievance defense, or for those of us who've interacted with anybody who's been sued really, or grieved, or brought into a licensing situation like this, one of the overwhelming reactions that defendants and licensees have is, hey, if I can just explain myself, if I can just tell my story, this will all go away. And the reality is that's not usually true. If you prep people for depositions, defendants for depositions, one of the common things I tell people over and over again is, hey, fight your instinct. It's too common for somebody to be asked, hey, do you remember this patient in a deposition? And then by the end of the answer, they've explained everything they can recall about the case. But that wasn't the question. The question was, do you remember the patient? And that reaction can get people in trouble. Because what happened in this case was the doctor was forthright, the chiropractor was forthright. He told the investigator what happened. He didn't worry about it too much. He didn't call a lawyer. And then he gets this. This is just a couple paragraphs from the administrative complaint. He'd admitted that during 2 football seasons, he did adjustments on multiple high school football players who were minors without consent, without written consent or any proper consent. And he failed to maintain records regarding his treatment. So now, and then in paragraph 6, you see, respondent admitted that he treated approximately 20 high school football players. So this is where I get involved. And when I get involved, if you take us to the next slide, this is what I'm looking at. Mistakes are made. This house is on fire. And that's a little hyperbolic, but the reality is now I've got a guy who had a history. He'd had a prior issue that he had to go through the disciplinary process for. Now he's admitted he treated 20 kids, minors, without consent, without record keeping at all. Probably 20 violations of the Michigan Health Code. It's a disaster. If I'm this guy, I'm worried about keeping my license at this stage, my livelihood. And this isn't somebody on the verge of retirement who made a mistake. This is a 40 some year old guy who's got a long career ahead of him, who's literally volunteering his time on the sidelines to try to help out a small town high school. He's coaching the middle school football team. He's out there doing this good work, and he has talked himself into a licensure investigation that could cost him his livelihood. And it's just everything went wrong. So I talked earlier about that instinct, that reflex. That is the first thing that went wrong, is he wanted to explain himself and he had no idea what he didn't know. Because if he knew what to do, if he called an attorney, if he called his insurance carrier, who would have been given a defense, he would have been given an attorney who would have asked, hey, where did this come from? He had kind of a thought on where it came from, but it turns out when we got the file, this was an allegation. This was a complaint that wasn't made by a patient. The complaint was made by a patient's chiropractor who heard the story about how, hey, I was at a football game and I wasn't feeling good, and Dr. So-and-so, saw it on the sideline and took a look at my back or hip or whatever it was. And then during halftime, we were in the training room. He made a quick adjustment, and boy, it really helped. And can you help me anymore, doctor? Well, the patient wasn't upset about this, but the patient's chiropractor, my client's crosstown rival, decides he's going to file a complaint because you shouldn't be doing that on the sidelines. Did he talk to your mom before he did an adjustment? Did he talk to your dad? Did he get a consent form signed? And so now we've got this like crosstown rivalry that's leading to a complaint. My client, when he did this investigation, this interview, didn't know the specific allegation. He didn't know which patients were involved, and he didn't know what the state had figured out. And those things are so important because the first question in this was, hey, doctor, do you keep medical records for these people that you see? Well, his answer was no. The answer was no, I don't keep records of patients that I've done adjustments for during these football games. But if he had the background information, the answer wouldn't have been no. The answer would have been which patients. And the onus would have been on the state to give them some information. And that might not have gotten him out of the woods, but boy, it would have been a lot better than, oh no. And yeah, I've seen about 20 patients where I've done adjustments on the sideline. And no, I don't have any medical records. And no, I don't have any consent forms. The reality was he had treated a lot of these kids in his office. And he wasn't doing random adjustments on random kids. He was primarily treating kids who he already had a relationship with. He had consents for in the office. And if he could have approached this from a different angle, he could have not only made that point, but he could have forced the state to say, well, what about this kid? And then they would have been talking about one individual. And this would have been a lot more manageable. But he didn't do that. And so he walked himself into a lot of problems as a result. The other thing that went wrong here is the licensee, when he doesn't get or she doesn't get an attorney or some counsel here, put themselves at a disadvantage because the licensee can't have the same conversations that we can, that the attorney can. It's just like a jury trial, right? The defendant in a jury trial can't always say the same things the attorney can. The attorney can say, hey, the plaintiff never followed up with his or her care. The plaintiff never did X, Y, and Z. But the defendant can't say that. And there's a reason for that. And the reason is hopefully intuitive, but I think the best way to explain it from my standpoint is the members of the jury are just like these investigators. They have a concept in their head of what a good doctor looks like. Maybe it's Marcus Welby, maybe it's Gregory House, maybe it's Santa Claus with a medical degree, I don't know. But they have something in their head about what a good doctor is. Maybe it's a middle-aged guy with white hair and an academic specialty, who knows? But if you can deliver that to the jury, you're ahead of the game because they see what they expect. They see a responsible, thoughtful, compassionate professional. And that's a good thing. And we want to deliver that whenever we can to the jury or to the investigator or to the assistant attorney general if that's where you're going. So the attorney can ask questions. The attorney can do things the licensee can't. And I'm just going to give two quick examples. The first is the attorneys can kind of call ahead of time and have a candid conversation with the investigator. I had a case, this is actually a little while back now, involving a birth trauma investigation. Now, I was representing the doctor in a birth trauma claim, and all of a sudden she's being reported for failing to deliver this child timely, failing to prevent this child's death, failing to do X, Y, and Z. Well, I call the investigator and say, hey, this is kind of weird. This child didn't even die. I don't understand what's going on. And I get the backstory. And the backstory is, well, the person who complained, I can't give you their name, but this person sends us these all the time. It's a watchdog organization or a woman who, purports to be a watchdog organization who reports abortion providers throughout the state wherever she can and tries to get them brought up on various disciplinary charges. So she follows these dockets and follows these public filings. Well, my doctor wasn't even an abortion provider, so I don't know how any of this happened, but that background gives you pretty helpful information for counseling your client on what they can say, what they don't want to say, and how to handle this. Also brings the stress level way down if you know that the investigator just has to get some of the file documented so she can make the right recommendations. The second example here is a recent case. I just handled a claim for a psychologist, and the complaint was from one of his patients that number one, he used two anecdotes during therapy sessions that this patient found offensive. And the second was this patient used was non-binary, identified as a non-binary individual, and went by they or them. And although appropriate pronouns were used during the therapy sessions, the medical records used he because it was a biological male. Well, there was no medical reason to use he or she in the records, and so the psychologist didn't use probably the right pronoun there, and made a mistake in his view. But to my eye, I don't think the state should be in the business of proofreading medical records. And whether it's pronouns or something that's less controversial, frankly, I don't think a mistake in a medical record like that should be the stuff of licensure debate. I also don't like the idea of a patient becoming offended, being able to now file a complaint and put somebody's license at issue. Thankfully, that's not how the legal profession works, because if every deponent I offended was able to file a grievance against me and successfully challenge my license, you wouldn't be listening to me today. You'd have to come and see me on the weekend putting on tile demonstrations at Home Depot. But thankfully, here we are. Those are points I can make to the state. Now, I don't think I'd make them like that, and I didn't make them like that. But a good attorney can artfully make those points. Hey, the state shouldn't really be in the business of policing pronoun usage in medical records. It's not a good use of their time. And these aren't the kind of mistakes that affect patient care for the most part. There may be exceptions, but really this is not something the state should be investigating from a licensure standpoint. I can say that, but my client can't make that point. And he can't make that point because we have to present him as somebody who is in the business of providing care to transgendered and non-binary individuals. So he's got to be somebody who's sensitive to those problems. He's got to be conversant with that language. He's got to be respectful of pronouns throughout the interview, and he can't say anything that might trivialize that. I have a little more flexibility because there's that distinction between the attorney and the physician, just like there is in a trial. The attorney can cross-examine a witness and can do so aggressively because there's that distinction. The jury, just like the investigator, won't judge the lawyer for asking tough questions and doing a little bit of an aggressive cross-exam. But that doctor, that defendant, that licensee, boy, they have to stay objective because we don't want to affect that image that we're presenting, and we don't want to alter that. So if a lawyer's not brought into this, even a very smart, even a well coached, well-educated, savvy licensee is at a disadvantage in an interview with the state because they just can't accomplish the same things that an objective representation can. Eric Raymar, my partner and colleague, is going to cover a lot of these in a little more detail, and I will turn over the presentation to him. Eric, take it away.
Thank you, Justin. And for everyone listening, Justin puts on a great trial advocacy course the first Saturday of every month at the Home Depot in Farmington. So it's worth going if you have the time. But my name is Eric Raymar. I'm a partner at Plunkett Cooney's Detroit office. I'm the co-lead of the medical litigation group, and I've been practicing for over 10 years, specializing specifically in the defense of healthcare providers in both civil actions, medical malpractice suits, and state investigations. So today, I'm going to focus specifically on that interview process as well as the events that occur before the actual request is made for an informal interview, and I use that term in quotations with the state investigator. So it's important to know, and it's always important to remember that anyone can file a complaint against a medical or mental health care provider with the Department of Licensing and Regulatory Affairs. As Justin had alluded to earlier, some of these complaints don't necessarily have any merit whatsoever. So the significance of that, and this will be touched upon later in my presentation here, is that if you do have a complaint filed against you, don't take that as there being any merit or any sort of basis for that particular complaint, but you still need to take it seriously. When a complaint's issued, the law investigator typically will have met with the individual who filed the complaint, will have reviewed any medical records to the extent that they exist, arising out of the at-issue care or treatment. And with that information at hand, the investigator then will reach out to the healthcare provider to request the informal interview. And when this occurs, this is where we always caution to exercise your right to have an attorney present. The initial contact from the state investigator typically comes by form of email or sometimes phone call, and the phone call contact is the most concerning because it puts the healthcare provider kind of on the spot to respond in that moment. I always advise the doctors and other healthcare providers that I work with to kind of put the onus on the attorney, or put the blame on the attorney and say, look, I have an attorney who helps me on other matters. They've always advised me that if a state investigator calls, just to call them first. That way you don't look like you're trying to hide anything. That way you don't look like you're trying to be elusive of the interview process. The state investigator understands this. They're not going to take that as any sort of admission of guilt or cover up. And it's in your best interests to bring attorney in early on in the case so you can properly prepare for and address what the claims are against you. Now, it's important to note that the state investigator, although friendly, we know them. Justin and I have dealt many times with the numerous state investigators in the department. They're friendly, but they're not your friend. They are there to investigate a claim and to draft a report outlining what they find to be the facts and the circumstances of that particular complaint. The inclination from the healthcare provider, from the doctor or nurse, is to explain yourself. And as Justin talked about earlier, this often puts yourself at a disadvantage. This often can create situations where you have to fix something that didn't necessarily need to be fixed down the road. One such situation is if a healthcare provider divulges too much information to the investigator who speaks beyond the scope of what the investigator was even looking at and puts themselves in a tough spot. And Justin's chiropractor example is a perfect example of giving too much information without even the investigator asking for that. And that's a situation where we always caution, if you had met with an attorney beforehand, the attorney could have done some investigation to determine what the scope of the state's file was. And we could have narrowed down what it is that they're looking at. Therefore, you're not divulging information that you didn't need to. When this initial call occurs with the state investigator, ideally, you would at that point contact your attorney, and the attorney would get involved and facilitate the informal interview process with the state investigator. And it's at that point where the attorney can start to investigate the claim on your behalf. And what we typically do is we speak with the investigator to find out exactly what it is that they're investigating. A lot of times the state investigator will be very willing to speak freely with the attorney and say, we have a complaint that outlines this, and we can get some information ahead of time that would be of significant benefit to the healthcare provider who may not know exactly what it is he or she's being investigated for. When I get a claim like this, if I get brought in early on, I always meet with the healthcare provider at least one time before the informal interview, and I think that's a minimum. And what I like to have the healthcare provider do before I even meet with them is called the prep before the prep. And this is where I ask the healthcare provider, based upon the information I was able to gather about the investigation, to one, review the patient file. If we're able to identify the patient, or if we're able to identify who the patient might be based upon information that we have, dates of treatment, allegations, I always ask the healthcare provider, review that patient file, identify any staff members who may have been present for the at-issue treatment or the at-issue care. One such example, a lot of times if there's a chaperone in the room for a breast examination or something like that, or if you had an assistant in the room with you during a procedure, that person oftentimes is going to be a very important person to the investigation, because more likely than not, they're going to corroborate what it is you're saying about what occurred during that particular encounter. A tale of caution: do not amend, do not supplement, do not otherwise change the records at this point in time. The last thing you want to do is have to explain why you amended a medical record after you received a call from a state investigator. That's the absolute worst case scenario that we can imagine in dealing with these types of investigations. The other point too is when you identify staff members who were involved, advise the staff. One, don't amend any patient records, but two, don't speak with the state investigator if they reach out to you for informal interview or for comment on their investigation. It may be counterintuitive to want to tell your staff, hey, the state's investigating me. But I think the downfall of not telling your staff is that they may inadvertently divulge information to a state investigator that would otherwise be harmful to your defense. And a lot of times the staff member doesn't necessarily know that they shouldn't talk to the state investigator without at first conferring with an attorney. And they may not even intend to say anything harmful to the doctor or the healthcare provider. They may be trying to help, but they may inadvertently give information that's not helpful. They may give information that's contradicted by the medical records, or they may make statements about another patient accidentally and not really have any idea what they're talking about. So it's important that at the very least that staff be aware, or at least staff that's involved, be aware that there's a complaint that's been filed. That doesn't mean there's any merit to the complaint, but to just be aware if they are contacted, to let you know and to let the attorney know so we can get involved and we can help. Now, one of the more important parts of this process is when you meet with the attorney. I always have as much information and documentation available to me before this meeting so we can thoroughly discuss and go over what I expect to be questions you're asked, topics that the interviewer is going to want to explore. It also gives us an opportunity to determine if the area of medicine that's going to be explored is a complicated area. And that's important because, as Justin talked about earlier, the state investigator oftentimes doesn't have a thorough medical background, and they may not understand the issue, or they may not understand the treatment or medication that is being investigated with respect to that particular complaint. So it's important to get a game plan in place to one, to explain the at issue care or treatment, and two, to be able to explain it at a level that the state investigator will be able to understand. He or she will be able to properly put in their report. That way it paints as well of a picture of you and the care that's at issue as possible, given the fact that we're sort of relying on the state investigator to receive that information, absorb that information, and then relay it in their report adequately. One other point of strategy, if you will, with respect to these is whether or not we want to get an expert involved early. Sometimes it's beneficial to have an expert review the case, draft an opinion on your behalf, and we submit that, or at least we provide that to the investigator in conjunction with our informal interview. A lot of times that makes it easier for the investigator to draft his or her report if they're staring at an expert report outlining why it is he believes you acted in compliance with the standard of care and didn't violate any public health code public health code violation. So that's something that's really case by case. That's of all the state investigations I've been retained to assist on, I think I've retained an expert on about 30% of those, maybe 40%. And it all kind of varies on the circumstances of that case. So it's important to at least have that discussion early on, give the expert some time to review, give his or her opinions, and be able to outline that in a formal document. Now, again, this is, we went over this, but meeting with your attorney, this is the time where I think it's important. I always like to have a mock interview formulated at that point in time. That way the healthcare provider gets a feel for what to expect during the informal interview process. He's gonna, I like to have the questions ready, say, this is what you're gonna be asked. Why don't you give me your response to this question? And then we can talk through your response to make sure that you're relaying the proper information that you wanna relay, why it is you may wanna include or omit certain information as part of that answer, because it may not be responsive to the question. That's oftentimes the most repeated example of what I say is like, look, I asked you a certain question and you volunteered way more information than that question asked, and that's why we should kind of shore up and give concise responses. Now, the informal interview process, Again, there's two typical approaches that the state investigator likes to have. He'll allow the individual to give a narrative response saying, look, you want to just tell me what you can remember about this patient and about this care, this is what the allegation is. Or he can say, we can do a more formal question and answer. And I always leave that up to the provider to decide. Oftentimes in my mock interview, I get a feel for whether or not this would be a good candidate to conduct a narrative response versus question and answer. The notion of agreeing to a narrative option really depends on whether or not you feel comfortable speaking concisely and succinctly. Again, question and answer gives you the opportunity to just answer the questions that the investigator puts forth. And the other point to that is, because it's an informal process, as your attorney, I'm sitting there with you. So I get to ask you questions as well. And I will know what questions to ask in order to properly bring to light information that I feel is beneficial to your case. So oftentimes I suggest, let's stick to the question and answer format. That way it prevents kind of that oversharing, or it prevents kind of the long-winded responses that may miss out on certain points that we think are important to that healthcare provider's defense to any investigation or claim. Now, John, if we go ahead a couple slides after the interview. So once the interview is done, and as Justin talked about, the interview is typically half an hour to an hour long, depending on the issues. But after the interview, the investigator may request some additional materials from you. He may interview additional witnesses. But once that's done, he submits his report, and we typically don't hear from the state for 4 to 6 months in some cases. So unfortunately for the healthcare provider, there's that hanging over his or her head for a long period of time. Now, the state investigator can typically do one of three things. And if you want to go ahead one slide, John, their written report could recommend, one, that the file be closed in their investigation based upon a failure to substantiate the actual allegation itself. 2, they refer for an expert to review and determine if the alleged conduct was below minimal standards for the profession. Or 3, and this is the most severe, that they recommend the file be transferred for drafting of a formal administrative complaint. And that's the point. If it goes to option 3, that's where a formal administrative complaint is going to be filed against the healthcare provider, and a compliance conference and a hearing in front of an ALJ will be conducted. And that's typically what we try to avoid. We try to avoid options 2 and 3 from occurring, which is why we thoroughly prepare the healthcare provider in this informal interview process to avoid options 2 and 3. I want to give a couple examples that I've had recently. These are 2 cases that I've dealt with where I represented a healthcare provider in a state investigation. The first example has to do with a nurse who was working in the ER. Now, this, ironically enough, this was a nurse. I'd given a presentation at the hospital years before this on a different topic. I met this nurse after the presentation, and then 2 years later, he called me out of the blue and said, hey, I got I think it was an email from the state investigator asking to meet with him. Can you help out? I said, sure, that's great. Did you respond to the investigator? He said, no, not yet, but I'd like for you to respond on my behalf, which I did. So we're off to a good start because he hasn't given any information to the investigator at all. So I reach out to the investigator, facilitate the informal interview, and I met with the nurse on a couple of occasions to prep him. Now, the allegations were he made the decision to place a patient in the EMS vestibule at the hospital, and the EMS vestibule has its window, so you can see in and out. The patient himself had come in. He was intoxicated but had suicidal ideation, so he was in restraints, and he was being volatile to other patients. Now, the nurse made the decision to move this patient out of the ER area because of how he was acting to other patients and moved him into the vestibule. Now, the investigator had previously spoken with an ER doc about the issue, and this is some of the information that the nurse wouldn't have known if he had spoken during that initial phone call. The ER doc had said, once I saw the patient out in the vestibule, I told the nurse, hey, you got to get him out of there. You can't have him in there. That's not right. Well, there were records that actually said otherwise. The doc had actually agreed with that decision based upon how the patient was acting. And then it wasn't until the patient had calmed down and they were able to put him in a separate room that the decision was made to then move him out. So the nurse gave a very, very good interview. He explained his thought process as to why he had moved the patient out. He explained his thought process and his actions in terms of, I communicated with the ER doc. All the other nursing staff was aware what was going on. Everyone could see him. He wasn't in the spot where no one was able to have eyes on the patient. And at the conclusion of the interview, the investigator said, okay, I'll let you know what happens in the future. And I think it was 4 months later, we got this letter, which John's on the next slide, which is a letter we all want to see, which says they're not able to substantiate the claims against the complainant and the file's been closed. So this to us is what we want. We want the informal interview process to go as well as it can be, and then we get a letter like this 4 months later saying we've closed the file, no action against your license. Next slide, we have another example, unfortunately, where I was retained, but I was retained after the informal interview process had occurred. Now, in this case, the social worker started a romantic relationship with one of his patients. The patient filed a complaint with the state, and the investigator called the social worker and asked about that particular allegation. And the social worker denied it, saying, no, I had ended the provider-patient relationship, and at some point thereafter, a romantic relationship began. So he's admitting to a romantic relationship, but he's claiming that, no, I had ended our work relationship or our provider-patient relationship earlier. Well, unfortunately, what the social worker didn't know was that the investigator had a series of text messages and treatment notes which showed that there was a significant overlap between treatment and romantic relationship. So the state investigator told the social worker, I'll give you a chance to think about your timeline of events, look at any records you might need to look at, and let me know if you still believe that there was a bifurcation of provider-patient relationship and romantic relationship. So social worker eventually returned a call and said, no, I terminated the provider relationship and I started a romantic relationship after the fact. Well, a formal administrative complaint was filed thereafter, and it outlined the misleading responses by the social worker. And after the formal complaint was filed, that's when I got a call saying, hey, can you help out? And I was happy to. Unfortunately, he had dug himself a pretty big hole based upon his misrepresentations to the state investigator. Now, after the formal administrative complaint was filed, we looked at the allegations, we looked at the evidence that they had against him, and determined that one of the big bases for their violations of the public health code was his misrepresentations that he had made, and it was all included in the text messages, which we would have been able to get had he just let me know that ahead of time. And what he missed out on by speaking with the state investigator freely and speaking without really having discussed the case with an attorney was he missed the opportunity to say, look, I made a mistake. I recognize that mistake. I've taken steps to make sure that I don't make that same mistake in the future, and it won't happen again. And acts of contrition like that are looked upon positively by the healthcare board that ultimately is going to determine the sanction that's levied against that licensee. And unfortunately, when you misrepresent facts and when you mislead the state investigator, the board doesn't take too positively to the licensee then saying, well, I recognize I made a mistake. It only happened once, it won't happen again, because they've now have it documented that he's already lied to the investigator once, and then he did it a second time in that follow-up phone call. So had he contacted an attorney earlier, we might have been able to put together a much stronger defense and ultimately had a much lesser sanction levied against the licensee's license in that situation. But unfortunately, we had a pretty big uphill battle from that based upon his willingness to speak with the investigator early on. I've included one question that I thought might get asked here, and maybe it already has, but does my insurance cover attorneys for these state investigations? Typically, yes. If you're insured under a private insurance policy, there's typically a rider in there that will account for attorney fees related to a state investigation. If you're insured through a hospital system, typically the hospital system also will have coverage for this type of representation. And going back to my first point, anyone can file a complaint. And the significance of that is if you get a complaint filed against you, there's no reason to hide that from your legal department at the hospital or from your insurer, because they're aware of that. They're aware of the fact that anyone can file a complaint. That doesn't mean it has merit. I think the worst thing you can do is try to keep the filing of a complaint against you secret from your employer or hospital or insurer, because then they can't do anything to help you out. And oftentimes that leads to what some of these bad stories and bad outcomes we've talked about today. A lot of times those can occur if you're trying to cover things up or trying to handle it on your own without the assistance of counsel or legal. So that's why we always recommend, if you get a complaint filed against you, tell the legal department, tell your insurer, tell them. They'll be able to help, and that's why, frankly, we're here to assist as well. John, I'll kick it back over to John to address any questions that may have been asked throughout this presentation. But thank you, everyone, for your time and for listening today.
Okay, thanks very much. We do have our questions window available to you for questions. If you'd like to toss one in there, we'll take them now. We do have one question right now. What happens if the investigator never calls you back?
This is a great question. Eric mentioned that it sometimes takes a little bit of time. I always tell people they can expect one of three things after the informal interview. Number one is you may get a letter, usually quickly, that says they've not been able to substantiate a violation of the Michigan Public Health Code and the case is closed. Number two is you get an administrative complaint. But number three is I think the state sometimes puts these in a drawer and then throws away the drawer. And I have some that have gone that way that are years old. And if they ever come back to life, there will be a lot of defenses, like equitable defenses and not acting within the statutory period of time and things like that. But I think sometimes they throw them away on purpose. And from my standpoint, that's fine with me. If they don't want to pursue them, that doesn't affect anybody's license, no problem. I alert the professional to that ahead of time, just so they know it's a possibility, because you'd hate for somebody to freak out and start calling the state because they haven't heard something in time and maybe something gets pulled out of the drawer. But that's a possibility, and that's always been my approach. I know not everybody agrees with me on that, but that's the way I handle those.
Okay, great. We do have another question. And again, type in your questions now. We'll be wrapping up shortly. Do investigators have to review all complaints, or can they kind of pick and choose?
I think they have to review everything. I don't think they have to do an investigation on everything. And we could check the authority on that. We'd have to look at the statute. Maybe Eric knows offhand, but my understanding is that they can be closed without any actions in some cases.
Okay. We have another question. When does a claim become a searchable event on LARA? And I assume they mean their website or public postings.
Ooh, can I kick that to Eric?
So certainly no. So certainly not when the initial complaint by the complainant is filed. That's not something that can be readily searchable. I think once a formal administrative complaint is filed, that might be something that's discoverable. Certainly if there's board action taken, but prior to that, there's not typically any sort of way to find that informal complaint through the LARA website.
Yeah, the LARA website tracks discipline. So when discipline is finalized, either in a settlement or, well, basically when the board approves either a settlement or an ALJ recommendation, that'll be on LARA. The question that I'm not sure about here is whether the administrative complaints themselves are locatable. They're probably a matter of public record, but I don't know if they're easily available somewhere or not. We'd have to dig into that to find the answer to that question. But Eric's absolutely right. The investigations are not public.
Okay, and we have one last question, unless anybody posts in the next couple seconds here. Can an insurance company decline to cover an investigation?
There's a coverage question. We have a whole separate department on that one. Boy, Eric muted himself awful quick on it. It's going to depend on the policy language. It's a coverage question, so it'll depend on both the policy language and then what's alleged. For example, you can imagine a lot of examples where perhaps an insurance company tailors its language to exclude, for example, complaints that are based upon inappropriate sexual conduct because there's a separate sexual conduct rider that they want people to purchase separately or something like that. So there are a lot of iterations, but that's really a policy language question.
Okay, great. That's all the questions we have. I'll kick it over to Claire to wrap it up.
Okay, before we end today's seminar, I would like to mention a few quick items. At the conclusion of the program, you'll receive a pop-up survey from our GoToWebinar service. We would really appreciate it if you take a few moments to complete it. We always love to receive your ideas for future webinars, so please be sure to indicate in your survey response the topics you would like us to address. In case you or a colleague would like to review today's session online, you can do so by visiting the event page of the firm's website, which can be found at www.plunkettcooney.com. At the top and bottom of each archived event page, we include the link to the recorded program, so you can find our previously recorded webinars for free at your convenience 24/7. Well, that concludes today's program. On behalf of Justin, Eric, and myself, thank you for attending today's webinar and have a great rest of your day.